Thank you very much, sir, for your passionate articulation of the hurdles standing in the way of judicial independence. May I now take this opportunity to welcome to the podium Constitutional Jurist par excellence, Senior Advocate Mr. Probir Neogi. Sir, if I may take this opportunity to pick your brain a little bit, to what extent do you think Ishtiaq sir's legacy or vision, rather, of an independent judiciary has materialized? Thank you very much, sir.
Justice of Bangladesh, judges, honorable judges of the Appellate Division and High Court Division of the Supreme Court of Bangladesh, distinguished panelists and learned Attorney General for Bangladesh, Honorable President of the Supreme Court Bar Association, Vice Chairman of Bangladesh Bar Council, distinguished keynote speaker, and very competent moderator, and learned senior advocates, and ladies and gentlemen present. A very good evening to everybody. Today's topic is Masdar Hussain case, the last battle of Barrister Soyed Ishtiaq Ahmed. We are in time constraint, so I will straight go to the essence of today's topic. This is our pursuit for achievement of independent judiciary. And in order to advance in this direction, we have to keep in mind our past experience and the process of changes through which our constitution has gone. To my very limited understanding of our constitution, that our constitution as it was originally adopted was a democratic constitution, though some very vital limitations were there. And if we straight go to our concern, that is our Supreme Court, independence of judiciary, we will find that in original Article 95 and Article 98, all our speakers have told about 116 and 115. But I think Article 95 and 98 is very important, because to ensure the independence of judiciary, the process of appointment, selection and appointment of judges is very important, very crucial. And this is laid down in our Constitution, Article 95 and 98. In original 1972 Constitution, I will just refer to this. 95 was like this, 95 Clause 1. The Chief Justice shall be appointed by the President and the other judges shall be appointed by the President after consultation with the Chief Justice. This was original 95 Clause 1 in 1972 Constitution. By 4th Amendment, Constitution 4th Amendment Act, this was made like this, quote unquote, the Chief Justice and other judges shall be appointed by the President. After consultation with the Chief Justice, deleted from the Constitution by Constitution 4th Amendment Act in 1975. Similarly, regarding provision of removal of judges, original 96, Article 96, Clause 2 was like this: a judge shall not be removed from his office except by an order of the President passed pursuant to a resolution of Parliament supported by a majority of not less than 2/3 of the total number of members of the Parliament. On the ground of misbehavior, blah, blah, blah. By 4th Amendment, it was made a judge may be removed from his office by order of the President on the ground of misbehavior or incapacity. And then by proviso, a ceremonial so-called notice provision was there. So, appointment and removal, total was brought in one hand by second proclamation order of number 4 of 1976, 1978. During martial law, the provision of Supreme Judicial Council was incorporated. Original 2/3 of Parliament, 4th Amendment by President, nothing required, and during martial law, by a martial law proclamation, second proclamation order, Supreme Judicial Council was incorporated in our Constitution, and that remained there intact till 16th Amendment. Till 16th Amendment, that remained there. So, these are the provisions relating to appointment of and removal of judges of our Supreme Court in our Constitution as originally provided, and as by 4th Amendment it was changed, and some democratic or some provisions conducive to our independence came back during martial law. We have to keep it in mind. And Article 116 in 1972 Constitution, it was like this, quote unquote, the control, including the power of posting, promotion and grant of leave and discipline of persons employed in the judicial service and magistrates exercising judicial functions shall vest in the Supreme Court. What was found during Mazdar Hussain case by our appellate division, that was not in the original 1972 Constitution. It vested in the Supreme Court, but by 4th Amendment in 1975, the change brought here, the control, including the power and posting of promotion, grant of leave and discipline of persons employed in the judicial service and magistrates exercising judicial functions shall vest in the President. The Supreme Court was substituted by the President, 4th Amendment. And again, by second proclamation of 1978, by second proclamation of 1978, under a general, a freedom fighter general, it was amended, modified. The control, including the power of posting, promotion and grant of leave and discipline of persons employed in the judicial service, etc., shall vest in the President and shall be exercised by him in consultation with the Supreme Court. And this Article 116, modified by a martial law proclamation, it remained. It is still today, till today, it is there. By 15th Amendment, it did not, they said that by 15th Amendment, we revised the 1972 Constitution as it was in its inception. No. In Article 116 in today's constitution as it was modified by Second Proclamation Order 1917. It is still there. And Supreme Judicial Council remained intact till 16th Amendment. So our pursuit for achieving an independent judiciary, we have to keep confidence যে সেই ভবিষ্যৎ উজ্জ্বল, কিন্তু পথটা আঁকা বাঁকা। This had to be kept in mind. In Mazdar Hussain case, appellate division 2 rounds, original case and then review. In High Court division, this case was heard by a division bench comprising 2 judges, Mr. Justice Mozammel Haq and Mr. Justice Hassan Amin. He came from subordinate judiciary. Just only to emphasize on a principle, I am referring to this, that in both the judges were of same view, but Mr. Justice Hassan Amin added a few words. He started with this: I am in agreement with the decision of my learned brother. However, I like to add a few lines in order to get myself clear to my conscience. Unquote. Then he wrote, in this connection, it may be recalled here that in spite of provisions as set out in Article 115 of the Constitution, the President of the Republic has failed to make rules. He wrote in his judgment, President of the Republic has failed to make rules. My very good friend Mahmoud Khobor is not here. ওনার বক্তৃতা শেষ হবে, আর এক মিটিংয়ে হয়তো চলে গেছে বক্তৃতা করতে, যে আমাদের এখানে everybody knows the story. They, excluding Chief Justice, other judges of the appellate division were invited to a dinner, and the then president told them, to me with proof, many serious allegations. You go there and let him know that you will not sit with him. None of them dared to ask, sir, please give us a reference and we will sit in Supreme Judicial Council. Provision was there. My Lord Justice Hassan Amin, some of who are from here, we have a pride that we are from the very beginning of our profession. We practice a constitutional and administrative law. And those who are in subordinate judiciary, they ended this after their passing LLB or LLM exam. Mr. Justice Hassan Amin wrote very short judgment. Mr. Mazdar Hussain is there, he knows. Very short judgment, only to say this, that President has failed. And why I refer to this part. My very humble understanding is that this is what is called practicing independence, to call black, to call white, and to call failure a failure. Because every one of us, we know that an individual or in an institution cannot become independent only by claiming independence or only by being conferred independence upon them, but by practicing it, by practicing this. So this is the position, and I have no time. So this is very important that after consultation with the Chief Justice, it is there, and in many judgments, that consultation means effective consultation. Consultation means this consultation must have primacy in selecting and appointing judges. And here, in this regard, I want to refer to my Lord Chief Justice in his speech, very valuable speech. He has mentioned this law, Supreme Court and বিচারক নিয়োগ অধ্যাদেশ number 3. I think that the anatomy of this law is something relevant for our today's topic. The appointment of Supreme Court Judges Ordinance 2025. Here, in analyzing this law ordinance, we have to keep in mind that statutes can supplement the Constitution, but cannot substitute the Constitution. In Article 95 to C, the qualifications of requirements of judges to be judges after 10 years of advocateship in this court, 10 years of service in judicial service, and other and some other requirements, qualifications for appointment of judges as may be fixed by law. In this case, some additional qualification may be added to the 10 years of advocateship or 10 years of service in subordinate judiciary. This is called supplementing to constitutional provisions by statutes, by statutory provisions. But I find, I may be wrong, but to my limited understanding, that I find here something which is not supplemental, absolutely substitutional, because in our Constitution, Article 95, Clause 1 provides the Chief Justice shall be appointed by the President and the other judges shall be appointed by the President after consultation with the Chief Justice. In Bangla, it is এবং প্রধান বিচারপতির সহিত পরামর্শ করিয়া রাষ্ট্রপতি অন্যান্য বিচারকগণ নিয়োগ দান করিবেন. So, this consultation is something which is exclusive between the President and the Chief Justice. No intruder in this process of consultation is permitted. But in this law, even it is not an act of parliament, it is an ordinance. Here, section 10 provides ধারা 7, 8 ও 9 এর অধীন কাউন্সিল কর্তৃক প্রণীত সুপারিশ প্রধান বিচারপতি সংবিধানের অনুচ্ছেদ 95 এর দফা 1 অনুসারে তাহার পরামর্শ রূপে রাষ্ট্রপতির নিকট প্রেরণ করিবেন. Constitution provides section 90 article 95 clause 1 that judges of the Supreme Court shall be appointed by the President after consultation with the Chief Justice. So, in course of consultation, the paramorshor advice that is of the Chief Justice tendered to President. Here, by this law, a council has been constituted. Honorable Chief Justice of Bangladesh is ex officio chairman of that council. Then one judge of appellate division, something like that, and 2 judges from the High Court division. These are there. And that council will recommend whom to appoint as judge only in case of equally divided, chairman of the council shall cast casting vote, deciding vote. And section 10 provides that council's decision shall be transmitted to the president by the chief justice as his advice within the meaning of Article 95, Clause 1 of the Constitution. So it is absolutely substitutional of the constitutional provision by the law. And in other words, this is called ultra-vires the Constitution. And under Article 7, Clause 2 of the Constitution, when it is said that any law is void to the extent of its inconsistency with the Constitution, this provision of Constitution tenders an implied caution to the lawmakers. What is that? Don't be wiser than the framers of the Constitution. Don't try to supersede the wisdom of the framers of the Constitution. And also there is other defects I have found, that actually this provision has rendered the highest office of judiciary, the Honorable Chief Justice, to the level of a post office, just to transmit the order of the decision of the council to the president, and this will be regarded as his advice within the meaning of Article 95, Clause 1 of the Constitution. And also in 3.2 ঘ council, composition of council, সেখানে কাউন্সিল প্রধান বিচারপতি, আপিল বিভাগে কর্মরত বিচারকদের মধ্যে হইতে কর্মে প্রবীণতম বিচারক, হাইকোর্ট বিভাগের বিচার কর্ম বিভাগ হইতে নিযুক্ত ব্যতীত কর্মরত বিচারকদের মধ্যে প্রবীণতম বিচারক, বিচার কর্ম বিভাগ হইতে নিযুক্ত হাইকোর্ট বিভাগের কর্মে প্রবীণতম বিচারক। I think this classification is not permitted in view of our constitutional provision, because somebody comes from subordinate judiciary, somebody goes from our bar, but when they take oath, they are posted in a constitutional post of judge of the Supreme Court, judges of the Supreme Court. Thereafter, no classification can be made from their origin. Before being appointed as judge of the Supreme Court, where from he came, from subordinate judiciary or from the bar. It cannot be, this cannot be classified in this way. Even in administrative service, এখন নাই, sometimes in some time past there was selection service board, superior service board. One from different cadres, deputy secretary level was promoted. Thereafter, there was an attempt from administrative cadre. Next promotion, joint secretary, there will be quota, 75% for administrative cadres and 25% from other cadre, deputy secretaries. But that was stopped. That once from different cadres, some persons are promoted to the rank of deputy secretary, then they are all deputy secretary, all are on same footing. There can be no further quota for promotion to higher strata, joint secretary or other additional secretary, etc. So I think that these are to be kept in mind. Now, in our jurisdiction regarding appointment of judges, confirmation of judges, a case was there. Latest one, I am happy that in that case, one is to others, which I appeared in that ABM Alta Hussain versus Bangladesh, one judge of the High Court Division, additional judge, was not confirmed. One of the observation has been contained in here. Once a recommendation went, but some defects were shown regarding that person, and that were placed again, sent back to the Honorable Chief Justice. If it is again sent with recommendation, then it has to be implemented within 15 days. It is, in other words, it's one observation of that judgment. It is here. It is positive. But before that, Bangladesh versus Idrisur Rahman, which was known as 10 judges case. Our some judges were not confirmed, and they were confirmed by this judgment. Okay. Here only one thing, the process by which judges, I am quoting, the process by which judges are appointed is therefore key to both the reality and the perception of independence. The whole scheme is to shut the doors of interference against executive under lock and key, and therefore prudence demands that such key should not be left in possession of the executive. So we have to preserve our independence, keeping it safe under lock and key, and this key cannot be left in the custody of the executive. So I would take this opportunity to speak further, but time constraint is there. I am grateful to everybody for giving me this opportunity, and I am grateful and thankful to all for hearing me with patience. Thank you, everybody.
Sir, the pleasure was all ours that we had the opportunity to pick your brains on such an important issue. That was very, very enlightening. In particular, sir has taken us